No, it's time.
You let me know when you're ready to roll.
Whenever you're ready. If you want, I can either record it or I can just take pictures.
It's up to Todd.
Give me 1 second, I gotta remember how to do that.
Yeah, because then you can always take a picture.
Oh, yeah, they don't need that.
Wow, it's hard.
Can you raise your right hand and repeat after me? I, Todd Thompson,
I, Todd Thompson,
have been appointed to the office of city manager in the city of Rock Island,
have been appointed to the office of city manager in the city of Rock Island,
in the county of Rock Island,
in the county of Rock Island,
do solemnly swear or affirm
do solemnly swear or affirm
that I will support the Constitution of the United States
that I will support the Constitution of the United States,
and the Constitution of the state of Illinois,
the Constitution of the state of Illinois,
and that I will faithfully discharge
and I will faithfully discharge
the duties of the office
the duties of the office
of city manager to the best of my ability.
of city manager to the best of my ability.
So help me God.
So help me God.
Congratulations.
Pose of him taking the office, since he was recording.
Pose or?
Switch over and get some pictures real quick.
Okay.
Posing, because he recorded it, so.
You want to pose, him with his hand up or anything else?
With your hand up?
No, the two of you face each other just with his hand up, posing.
He recorded all that, so he didn't take a picture.
There you go, posing.
Got it?
I love that smile.
Yeah, that'd be good.
Go bring over to the council.
That's fine, we can bring up who's ever up there, that's fine.
That's good.
Those that aren't here, miss out.
I'm sitting back here. I'm not photobombing it in that way.
Congratulations. Thank you.
All right, time to go home. So Jenny said, too, stand up.
So, George?
Press release for this one, too.
Yes,
Oh, yeah.
yes, we do.
Let's do it. Let's do it.
Yeah, we got good pictures of them, and
That's exactly. All right. We are ready to call the study session to order.
this meeting will be conducted by audio and video conference without a physically present quorum of the Rock Island City Council due to the disaster declaration issued by Governor Pritzker. Because of this order related to COVID-19 health concerns affecting the state and the city, the mayor has determined that an in-person meeting at City Hall with all participants may not be practical or prudent. Alderpersons and staff may not all be physically present at City Hall due to the disaster, and physical attendance at City Hall may be limited. To participate remotely during the public comment or public hearing portion of the meeting, please join by phone at 1-662-506-2139, PIN 105-786-763 #.
Thank you very much. Roll call.
Alderperson Robinson. Hurt. Gilbert.
Present.
Swanson. Here. Parker. Pulis.
Here.
Healy.
Here.
Mayor Tomes.
Here. Thank you. Public comment. Any public comment out there? Virtual? Seeing and hearing none. We will then start with our presentation. Is Hector,
I'll start us off.
you got to start us off?
Yeah, Dave and I are going to do like the old wrestling on Saturday morning TV. We'll tag each other in and out. First, just a quick little bit of history. And Tim, wherever you are, if you can call up the old ordinance. One of the first projects I was tasked with when I joined the legal department, 5 years or so ago, had to do with frustrations that the members of the Human Rights Commission were experiencing. The current ordinance that enables... Hello?
Hello. How are you?
Good.
I wasn't sure if this was live, so this is live. Hey everyone. I'm gonna let y'all continue speaking. When it's time for me to speak, just let me know.
Who is this, may I ask?
My name is Donica Johnson.
Public comment?
Did you, were
And I
you
just
looking to
have-
speak, were you looking to speak for public comment, or?
Public comment, yes.
Oh, I can sit down for that.
Okay, we've already had that, but yes, go ahead. If you want to
Yeah, I
speak.
just got the live notification. It just went live, so I wasn't sure if it was live on this end, but it is. So I just have a quick question. I am not able to see who's all in the room, but I'm just wondering if there is someone there that would have information on the new federal building that's being built. I know that y'all have broke ground, but my question is, I would like to see if someone can give me information on who's working on that. Is anyone there? Because I have a request for a restroom, a gender-neutral restroom for the LGBT trans community. Because there's been some things going on around Rock Island with this whole restroom situation thing. If you remember, what was that, 4/11, I had spoke about the whole transgender situation. So yeah, is there anyone there that know who I can speak with, like the department or anyone about that?
Ms. Johnson, this is Hector Leroux. I'm one of the city attorneys. Because the new federal building is federal, the city doesn't have a whole lot of jurisdiction over how it goes up or who is involved in it. However, the chief judge that's in charge of erecting the building is the Honorable Sarah Darrow. And if you search on the internet for the United States District Court for the Central District of Illinois, there should be a link that takes you to all the different judges. If you search for Judge Darrow, there should be a number where you can reach one of her assistants in her chambers, and you can raise that concern with her, because I believe she is the person with authority to make that kind of decision.
Wow, okay. That was what I was looking for, just a name, someone that I can direct this question to and all other things. So I appreciate you so much for answering my question, and I will let y'all continue on.
Okay, thank you very much.
Gratitude, everyone. Bye-bye.
All right, Hector.
Kind of a neat question. So, picking up where I left off, the frustration with this existing ordinance, and Tim, can you scroll just to show us how brief this ordinance is? The end. It's roughly a page and a half, and it gave the Human Rights Commission existence and tasked it with some general duties and powers, mostly of the advise and consent variety. People could approach the commission with complaints of discrimination related to immutable human characteristics, the general categories of things that are encountered and addressed in civil rights statutes and ordinances. But the commission had, and still has, as of today with that ordinance rather, no authority to actually render a judgment or make a decision or enforce a policy related to discrimination. The most it could do, and it did and has done this very actively, and to the Commission's credit, is engage with people who have complaints of discrimination and with the people about whom they're complaining. And they've had considerable success, some recent, as we learned at the last commission meeting, in bringing people together to resolve complaints and effect some real changes. That's on the one hand. On the other hand, there has been, certainly during my entire tenure in the legal department, frustration amongst the commission, and I think amongst some of the elected officials for the city, that the commission doesn't have the authority to force somebody to come to the table and engage in some kind of process to resolve a complaint of discrimination. In other words, if an employer discriminates against somebody on the basis of race or sex or religion or, all the usual litany of things, the commission members could call and say, we'd like to talk to you about this, and the person could say, no, thank you. And that was kind of the end of it. Originally, the request was we need subpoena power so that we can get records from people, but you can't have subpoenas without actual contested proceedings being involved. So there was a push some years ago to craft something like the ordinance that's proposed today, and that sort of fizzled. And then there was some renewed energy, and Dave and I spent a substantial amount of time going through the Illinois Human Rights Act and consulting with municipal council for other similarly sized cities in Illinois regarding their ordinances and their experiences with them, the troubles they'd had, and so on and so forth. And after that very detailed process, we drew the ordinance that is proposed tonight. We're not here to talk, Dave and I aren't here anyway, to talk about the policy behind that ordinance. We were tasked with crafting something that suited a certain litany of needs, and we think we have done that by pulling together the best provisions of a number of different ordinances and using the Illinois Human Rights Act, which is sort of a thing which we cannot reasonably exceed even in the exercise of our home rule powers. So, in general, the proposed ordinance defines areas of jurisdiction over which the Human Rights Commission can engage complaints and require parties complained about to respond. Those include employment, housing, public accommodations, and similar things. Those are all defined in the proposed ordinance. Redefining definitions is probably not a productive use of the council's time. I think the most important provisions of the proposed ordinance, at least outside the idea of, what is an immigration-related practice, that's a very technical provision that is the definitions required by the significant body of case law that's developed, and so on and so forth. Again, all the different provisions that are quite technical. The most important part of the ordinance from an operational standpoint, it's right at the end here. 2705. Tim, if you could open the new one and scroll down way towards the end, it's like the last 3-4 pages, section 2-705. There we go. This is the procedural aspects of the ordinance, as I said, are drawn from a number of different ordinances and the Illinois Human Rights Act. The process starts with a complaint, and the complaint has to be in writing. It has to be filed with the commission, and particularly the executive director, who's not here because he has strep throat and might have COVID as well. So Jerry's got a doctor's excuse tonight. On receipt of a complaint that is timely filed, and timely filed means within 90 days of the complained of act, the executive director will direct 2 investigators from the commission. And I should say that this ordinance structures the commission essentially into 2 separate bodies. One sits as a fact finder and applier of law. That consists of 7 of the commission members. 6 of the commission members are active investigators. In order to avoid open meetings problems, which are everywhere, and Dave and I wrestled with this at substantial length, we've come up with best practices, which would be that complaints are routed through the executive director, who will designate 2 investigators of the 6 investigators to conduct an investigation. The initial investigation is brief. It's just reviewing the facts alleged in the complaint and essentially interviewing the complainant and seeing briefly if there's a reason to engage with the respondent. The idea is that brief initial intake process will result in identifying probable cause, which, as you know, is a super low threshold to clear. Do we think it's possible that this happened? In the event probable cause is identified, then a written complaint detailing the facts is issued to the responding party, and it's to be served either by certified mail, with a little green card on for return receipt, or by personal process server, because notice is one of the key components of due process. And without notice, the rest of the proceedings can't happen. The respondent then has 28 days to file a written response with the commission, again, through the executive director. And at that point, a few different things can happen. The investigators can try to engage in informal resolutions. Lawyers call it alternative dispute resolution. In other words, sit down, see if you can come to something that everybody can shake hands on without going through a formal trial-type process. Assuming that works, then the case is done, and the commission retains jurisdiction for a year for enforcement purposes to make sure that the agreement is honored. If that doesn't work, then, or if the complaint is dismissed, because after, answer and all that stuff, they say, nope, there's no jurisdiction, or if it is dismissed initially for lack of probable cause. In any of those 3 circumstances, there can be an informal public hearing, which will be presided over by 3 people, conceptually from the 7-member fact-finding part of, the adjudicatory half-ish, half-plus of the commission. And that would be very much like a trial. And then if that informal hearing does not work, then a proper public hearing will be conducted with a hearing officer controlling the order of proofs, and the city attorney's office acting as prosecutor, but it's not a criminal, prosecutor is a bad word, but as the burden-carrying advocate. And the conduct of that hearing would be very much like a trial, rights to confront and cross-examine witnesses and so on and so forth. And the proofs would be admitted according to the Illinois Rules of Evidence, although presumably relaxed because it's an administrative proceeding. At the end of that proceeding, which will be presided over by the hearing officer sitting as sort of the traffic cop for the 7 adjudicatory members, they will discuss and debate and come up with an answer, and render a written decision. I've acted as hearing officer for a number of school boards in the past, and in my capacity as hearing officer, I'll take what the school board says the result is and reduce it to writing and cite the applicable law and all that kind of stuff for them to sign and for that to pass out. So, what's the upshot of a finding of liability at one of these trials? That's the administration and enforcement part, which is in the next section, 2-801. Fines are capped at $500. There's a statutory reason for that. But the commission can also issue cease and desist orders, which stop violating human rights, essentially is what that is. There can be calculations of damages, hiring, reinstatement, those kinds of things. And those are all administrative judgments, just like the ones that we get at the municipal code enforcement system proceedings. They're judgments, they're there, but they're not very enforceable through administrative means. So in order to make them work, if we don't get voluntary compliance from the respondent, would be to go to the circuit court, register the administrative judgment, and then commence actual civil court proceedings to enforce the judgment. Just as we do with, the people who get monetary judgments for having their grass grow too long or, have the outside of their building fall off or whatever. You can't just enforce those. You have to go to court and then enforce them. And that's the institution of civil proceedings section. So that's an upshot of the procedural aspects of the proposed ordinance. The substantive aspects are essentially definitional, and the definitions are highly technical because they come from a highly developed body of law that admits of many exceptions and nuances and so on and so forth. If anybody has questions or concerns about those definitions of jurisdictional scope and the people and acts upon whom that jurisdictional scope can operate, Dave and I are happy to field them, but I think that's kind of the overview. If anybody has any particular questions, we're all ears. Alderperson Gilbert?
Want me to start? Okay. So, going back to section 2-271. So you've got 13 members of the commission, 7 are the ones that decide on the matter, correct? And
Correct.
the other 6 are the investigators.
Correct.
So they would not be having them, since they each have very specific defined roles, there's not going to be like 13 people at a meeting.
Well, if the meeting is to take up matters other than investigations, then yes, there would be 13 people at the meeting.
That, no.
Right, but if they're accepting a grant or deciding to apply for a grant or how to use the grant funds, all that's all 13 members.
Right, okay. So, and I noticed that the 7 objectives of the commission are the same as they were in the old ordinance.
Correct.
So, yeah, I encourage the commission to really contribute on those things. Okay, so then the commission as a whole meets monthly, right? Okay, that's just on general stuff.
Correct.
Right? Okay. Pardon me, because it's 35 pages, so I've got like questions throughout here, trying to understand what all of this actually means.
And the reason that we end up with 35 pages is because in order to have the subpoena power, you also, as Hector had mentioned, you have to have all of the trappings of due process for letting people know what is prohibited behavior. If you're going to be subjecting them to a penalty of some sort, you have to put in the definitions of what's prohibited. Also, you have to put in the structure of how is notice. Due process requires setting out specifically how notice works, how the appeal process works, how administrative review works. So all of those become necessary to comply with the due process requirements.
Okay. So in section 2-303, arrest record. So does that mean if there are applicants for a job who have an arrest record, that an employer cannot use that to disqualify an applicant? Is that what that means?
Let us get to that section, but there are...
Or if they have a conviction record?
Well, there are two sections. There is a conviction section.
And an arrest record,
Arrest
yeah,
record.
but I have the same question for both, I guess.
So there are state and federal laws which allow consider what you can and can't consider with regard to an employment application, whether it be conviction or whether it be an arrest record. And then there are exceptions for certain types of employment that are also listed in the ordinance.
I believe that took into effect in Illinois March 23rd this year, I believe so.
I'm not certain on the date, but I
Think so.
believe
Because in the past, I always remembered on every application, they asked you that, like if you ever been arrested, if you ever been convicted.
Right. There has been a big push regarding expungement of records and also to make people more eligible for employment. There's been a change in the law, as indicated by Alderman Healy, in that regard. And so this is structured to address those situations, both for arrests and convictions, and what jobs there are exceptions for. So in other words, there are certain jobs where they say, well, if you have been convicted of a felony, you are precluded, and that's an exception. And those are listed out in the ordinance.
Okay, yeah, so if somebody was arrested but not convicted, or for like stealing in a previous job or something, you can't.
So it's going to be a case-by-case basis. So for
Right.
instance, I might be walking across the street, and they might say, hey, there's a guy that matches my description that just stole a car. They come and they arrest me, and it turns out, oh, it was some other guy that looked a lot like me.
Right.
That's a different situation than if I was, I'm sorry? And so that would be a different situation than, for instance, if I was the guy who did it, I pled guilty to it and was convicted of a felony. Those are different types of situations, and how you can treat those depends on the job you're applying for and what the disposition was of your arrest and so forth, and that's set forth in the ordinance and in the statutory law.
I wonder how many of our smaller businesses are aware of these new laws and, you know, what you can and can't ask and.
Right, well, and as Alderperson Healy and Dave pointed out, this ordinance reflects the current state of state law. So, I mean, if they're surprised by this, they're surprised by the state law as well, because they mirror each other.
Right.
So
Okay.
can I ask a question to piggyback that? What is different in this ordinance than state law? Or is this just pulled directly from state law?
It is not pulled directly from state law.
Okay.
And one of the, okay.
I'll have a follow-up, so.
Okay, one of the biggest differences, and this is a meaningful one from the complainant's perspective, is that this ordinance does not assign concurrent jurisdiction to the Illinois Department of Human Rights or the federal EEOC. If you get a probable cause letter from the City of Rock Island's Human Rights Commission, you do not have the right to proceed in court immediately, nor do you have the right to have IDHR or EEOC immediately assume jurisdiction over your complaint. If you want to make a federal case or you want to make a big state case, you've got to go to those two bigger agencies. There's no work sharing involved in our ordinance. And in that sense, the city ordinance is much, much narrower than the state ordinance and the federal statute. With respect to other ways, it is dissimilar. It was not pulled wholesale, as I said, from the Illinois Human Rights Act. It does not include things like government contracting awards, because then the Human Rights Commission would be essentially acting as prosecutor against its enabling body, which would be a real problem. So there are, and honestly, my notes for all the things that I scratched out of various things are compendious and not with me, but there are differences, and they are
So-
significant.
Let me run through a process. I get fined, I'm a business, I get fined $500. I lose my license, so you take my food license away, okay?
The Human Rights Commission does not have authority to take your
Okay,
license away.
okay, so you fine me. What if I hire a lawyer and I say I'm going to fight this because you're not a judge? How does that set the city up for any liability? Because
Okay, well.
that would be the
okay,
first thing I would do.
You're asking a couple of different questions,
Okay.
and I'll try and answer both
You
of them.
fine me $500. I hire a lawyer.
I fine you $500.
Yep.
You hire a lawyer, your lawyer
Because-
says, fine, you don't have to pay it because they don't have any enforcement authority.
Okay.
Then somebody calls Dave and me and says, enforce this. Then we're in the circuit court over at the courthouse saying, we want our $500, judge, sign an order, and if he doesn't give it to us, we're going to send the sheriff and take his bank account, or whatever.
Okay.
Okay. So your lawyer says, well, Mr. Healy, what do you want to do about this? And you say, I hate them and everybody that looks like them and everybody that smells like them, I want to counter-sue.
There you go.
And the answer to can you sue is always, always yes.
Yeah.
Can you get anywhere with your suit is a super different question.
Yeah.
And there's compendious immunities that would protect us from this. This is a fundamentally discretionary action by the city from start to finish, which would immunize us under the State Tort Act.
As everyone knows, there is a cost associated with that. It certainly is
Absolutely.
possible. If you just said, hey, I'm upset, I want to hire my lawyers to cause as much trouble as I can for you guys, and
Yeah.
money's not an object, you certainly could, and the city would have to defend. I think that's part of your point.
It is. It's more, is it opening up a can of worms since most of this is state mandated anyway? I mean, it's state law, so are we reinventing the wheel?
Yeah, that's exactly right, yeah. So is it duplicative largely of what IDHR and EEOC can do? Largely, yes. However, we've got an active commission that is more interested in exercising local jurisdiction than either IDHR or EEOC. But you're asking a policy question. The practical question, does it open a can of worms? Sure. I mean, IDHR has been dragged to federal court successfully a number of times. There's a standing, not consent decree, but a standing injunction against IDHR from doing certain things with respect to its probable cause findings. And that was the result of, I think, 7 years of federal litigation, which was expensive. So, I mean, once you start the litigation engine running, it burns a lot of fuel.
I guess as a business owner, I just hate not having a judge determine something rather than having a commission. And that's just me
Well,
personally.
Okay, so
And I understand. So-
when it comes to the Illinois Department of Human Rights, any other civil rights complaint, you don't get a judge. You go to the Illinois Department of Human Rights, and they have investigators, and they have a different arrangement for how they adjudicate things, but they do have an adjudication process. You go to the federal EEOC, you don't have a judge, you have an administrative agency. And you can't get to court without exhausting your administrative remedies.
So to clarify, what you call the exhaustion doctrine is if you go through the administrative process, you can't get to a judge at the end of the
At the end.
process. Then the judge will go back and look at things such as, and that's why, once again, we have as many pages as we do, with their due process, were they properly notified, was there, and maybe they can redo the entire meeting, basically, to make sure that you followed the rules and that there was that the party was, agreed party was afforded due process. So you can end up with a judge, and very much similar to the Municip's situation where you've got somebody who has a code violation, they're fined $5,000, they say, hey, I don't like that, they have a period of time in which to appeal that to the district court, and have the judge look at it and see whether it is going to stand or not.
I have more questions.
Sure.
Okay. So in section 409, exemptions, capital A, 1A, for the private sales of single-family homes, any sale of a single-family home by its owner so long as the following criteria are met. The owner does not own or have a beneficial interest in more than 3 single-family homes at the time of the sale. What does that mean, and why is that in there? So like, if I'm a seller, and I own 3 or more single-family homes, I'm exempt? Is that what that's saying?
The exemption, I believe, is the converse.
Well, yeah, it's the owner does not.
Right.
I'm sorry,
So
wait.
If you're a corporate owner, in other words, that's what this is getting at, is somebody who is in the business of owning, flipping.
So you may see the signs for people that say, "We buy houses," okay?
Right.
And they have 20 single-family residences for sale, and that's what they do for business. They buy them down at the courthouse in foreclosure sales, and then they rehab them, and then they put them up for sale. If that is part of your business, you are not exempt. What they're saying is, if you are a single, you own your own home, you own one, or maybe you own one here and one in Florida, then you fall within the exemption. But if you're somebody who has more than, and so that's to deal with basically people who are selling residential homes as a commercial enterprise to make money.
Okay. So then I go down to, which section is this? So I don't know.
You
But-
need this. You're-
For section 501 definitions, the child sex offender refusal to rent.
So could you give me that code section one more time?
Well, I gotta go back, there's so many things. It's under the exemptions, it's the last one, J.
Okay.
And I can't tell you what page number it is, because there's page numbers. So, what exactly is that saying? You can't refuse to rent to a child sex offender, or
You can refuse.
you can refuse?
You can.
Can.
C-A-N, C-A-N, can. Not
Can
cannot.
refuse to rent to a sex offender, is that correct?
That's correct.
Just wanted to clarify
Sure.
that. I know that was a question several of us had.
And there are also a number of other state regulations on that particular issue about where persons can or can't live.
Right.
Oh,
yes.
Parks and
Oh, yeah.
churches, and there are a
Yep.
whole bunch of other
Oh, yes,
regulations too.
absolutely. Okay, then going to section 2-701, powers and duties. So, A, rules and regulations to adopt, promulgate, amend, and rescind rules and regulations not inconsistent with the provisions of this ordinance and other applicable laws.
Right, so that would be like the adoption of, say, bylaws and things by the commission that are not in conflict with the ordinance itself.
All right. And then, I don't know, I have a note here, and I don't know which one this was. Oh, D, complaints. Oh, wait, is that it? Commissioners can file complaints, or am I reading that wrong?
They can, and the question that the commissioners have brought to me is, may they file complaints on behalf of others? And that answer is no, because then they would be practicing law and advocating for a matter that is within their jurisdiction.
Okay,
But commissioners can, on perceiving a pervasive pattern of civil rights violations, make a complaint saying that we see this pattern of behavior within the jurisdiction of the city, and we bring this complaint, sua sponte is what lawyers call it. I would anticipate that this would be used seldom,
okay,
and that if anybody wants to use it, they're going to call Dave and me first, because it is ticklish.
Okay, so moving down to J, education and training, to implement a formal and unbiased program of education and training for all employees. What employees is the commission going to have?
Well, employees is members of the commission assigned to investigate and conciliate.
That's not what it says. It
Well-
says employees, so then,
Well, but employees is anybody employed by, whether for compensation or not.
they're appointed, right?
Their definition.
Okay, so that brings up the question
Not according to
of
this.
funding. Is there a budget for this Human Rights Commission?
That's my
Because-
question.
Yeah, because there's something later, further down in my notes about something, and I'm like, okay, what's the budget for this?
That's a
Besides
question for
the-
Jerry, not us.
Besides the education and training, oh, there's so many pages, it's like, oh, when the city attorney institutes civil proceedings, who's paying your bill?
Well, it would have to be either the commission through the city or the city. And once again, these would be requirements of any, if you want to go forward with subpoena power, and then once again, it's a policy decision. We were asked to put together an ordinance that would get us to that area, and that's what we've done.
So, like, ballpark,
If
what's
the
the,
complainant isn't validated, could they have to pay lawyer fees then?
Nope.
So the city's just stuck with it? Great.
What if they went ahead and, say, subpoenaed records from the police department, and the police department said, no, you represent the police department, do you also I mean, you can't.
We would not be able to.
So then there's a
Well,
private
the
attorney brought in, and who
The
pays
commission should not have
that?
jurisdiction over the police department under this ordinance.
I mean, I just see the city being on the hook for a lot of money, and I don't know where we're going to get it from.
But again, that's a policy decision that's beyond the scope of anything Dave and I are,
Right. Oh, I get that, I'm just asking.
well, yeah, so like, to issue a subpoena, I have no idea. So what is like a ballpark cost to issue one subpoena?
well, presumably that's something that the commission members could do on their own.
Oh,
But then if it's challenged, that's when you come in.
Correct.
Yes.
And the same with initiating a complaint. I mean, if it's served by certified return receipt mail, that's, I don't know, what is that, $5.70 or something? But to have an actual process server go to a place of business and serve a real person
Probably $75, $80.
is probably $75, $80. But that's a necessary expense for due process purposes if the certified return receipt is refused, which often happens because nobody gets good mail with that green card
Right.
attached.
Our understanding also from talking with the commission members is I think maybe there's been one or two times in the last several years that they were wanting to use the subpoena power. I can't predict the future, but one time in 5 years, I guess. So anecdotally, and of course, there's no way to predict the future, but they've had one instance in the last 5 years where they had an employer or, I'm sorry, a person that would not cooperate, and they would like to have had subpoena power in order to bring them to the table.
But would you not be able, in that case, to go to the Illinois Department of Human Rights and have them, since they have subpoena power, could they not issue it?
If it's certainly an issue, yeah, you could.
Okay.
Hi, this is Christiana. Sorry, I just wanted to make a comment on that. I'm a commission member who's been on the board, I think, 4 or 5 years. As far as referring it to the state, sometimes there are some time constraints for the time the incident happened to when the person fills out a complaint, to the time we see it. And so potentially sending it on to the state, while that's a possibility, and we do recommend that to many of the cases, sometimes we're working within a time constraint as well, of having to deal with that.
And the time constraints with regard to the ordinance talk about 90 days or 90 days from discovery. So let's say something happened and it's the 180th day, you haven't been able to, you didn't discover the problem, you can still file, but it's a 1 year, it has to be filed within 1 year, and I think that complies with the same timeline as the state, I believe.
So you wanted me to repeat, so the Illinois Department of Human Rights has subpoena power.
Right.
And so the local human rights commissions can ask the Illinois Department of Human Rights to issue a subpoena on their behalf.
No, it has to be, it would have to be their own separate case.
Their own separate- okay.
You can't ask, you can refer a case and say you should file with the state of Illinois, and if the state of Illinois takes the case up, they could ask for a subpoena, but you cannot have a City of Rock Island case pending and then they go to
You
the state.
can't have, they
Right.
can't come to us and then go to IDHR and go to EEOC, once the case is filed with us, unless the commissioners decide, oh, we should refer this.
They could not, the state could not issue a subpoena in a case that is open in here locally.
That's
under
what
the
I
ordinance.
wanted clarified.
Okay.
But a referral could take place, say, from the local commission saying, hey, we're going to refer you to the state of Illinois. Sure, what's it, sure. And what I've done, as Hector and I, we spoke with the commission members last Thursday, and we invited them to come today because I don't know what, we haven't experienced all the things that they may have experienced, and I thought it might be helpful that we all be in the same room so we can talk about those experiences, and I guess with the indulgence of the mayor and the council.
Right, before you speak, the one person who was on the virtually, what was your name? Just so we have it for the minutes?
Christiana
Okay.
Headley.
She's on the commission.
Chris, yeah, I just want to make sure that, we look that up, I just want to, from the minutes, know who it was, Christiana.
Greg Hampton, entering my 5th year of Human Rights Commission. I think this really is a question of whether we want to be neighbors to our own neighbors. And there are obviously other apparatus. If someone wanted to file with the Illinois, we could just tell everybody to do that. I mean, I suppose, but we want to be able to be neighbors to our neighbors. And we want to be able to be the ones that help moderate those conversations, even if they don't go well at first. It's better for our city, for us to be the ones that handle our own problems, to help our neighbors and businesses and employees, et cetera, and so forth, to learn how to reconcile with each other instead of handing it off to a larger government agency, which may not actually lend itself towards those people reconciling. Our goal, our number one goal has always been to moderate and reconcile, not to punish, not to be punitive. Our desire is to have conversations and help people come to a place of reconciliation when they have been discriminatory, maybe sometimes without realizing it, maybe sometimes on purpose, but in the end the desire is for there to be reconciliation. There is an unknown amount of money that comes along with that, potentially. We have no idea. We don't know. I know that makes people in your position uncomfortable. I'm sure I apologize that there's nothing that we can probably do to answer those questions fully. But I think that at the end of the day, we come to the place where we realize that we have the opportunity to be neighbors to our neighbors instead of asking the state to solve our problems. We will be better at the end of this year, the end of the next 5 years, the end of this next decade, as a city for caring for each other instead of asking someone else to do it. Those are my 2 cents. I got to go coach a baseball game.
Can you not do that without subpoena power?
You know what? I don't know.
They've been able to do it all except for that one case, the way it's been for 5 years.
It has been rare that there has not been a resolution. That one included someone not losing a job, so they lost employment, they lost gainful abilities. That affected their family, and there was no recourse for them. And because of timing, it affected their ability or choices when it came to filing with the state of Illinois. So it does help, and it was a local business that calls this city their home, and so we would like to be a part of solving those problems. Yep.
Thank you.
I'm Margie Mejia Carabello. member of the Civil Rights Commission. And so my response to the subpoena powers, you need to understand that as a group, without subpoena powers, we can't even talk to people. Like we call, hi, this is Margie, I'm calling you about this issue, I'd like to set up a time to meet with you. I'm not going to talk to you. And so we can't move forward or move forward as quickly as we would like to when we don't have subpoena powers to either talk to people, to look at reports even. We can't make really good decisions when people are not sharing the information. And I really think, will we use subpoena powers a whole lot if it's instituted? Maybe not, because I think that's one of those things that people will be aware. I kind of should cooperate with you because I know you can get this information one way or another. And so that would really help us. In terms of the money, I think that you need to look at, you're going to pay money. You're either going to pay it up front with us in the small amounts because our work is not costing you inordinate amounts of money, or you're going to see some of these cases go into litigation, go to court, and you're paying attorneys, the city's paying out money. I mean, it's going to cost. And you see that cost across the nation. And so, I mean, we're just asking for your support to give us some things to help us do our job better.
Thank you.
No.
Go ahead, Todd.
I just wanted to clarify, you can have subpoena power without having enforcement power. I think most of your expense will come if you have to enforce these actions or have hearings. And one question I had about that is, did you come across any examples where, for the enforcement process, there was an independent hearing officer assigned? I just am a little concerned that some might argue that it's problematic having one body investigate, prosecute, and determine the outcome of cases.
You want to answer that, Hector?
I guess I'm probably qualified to speak to that because I've acted as an independent hearing officer for a number of different school districts in administrative hearings arising under the Individuals with Disabilities Education Act and Section 504 of the Rehab Act. So I know that apparatus exists, and my role as hearing officer in those cases is to control the evidence as it comes in, and then consult with the body regarding their desired outcome. There have been several school boards that have said, we want you to hear the evidence, we want you to draw a proposed disposition for us to vote on whether to approve or modify or reject. That's actually been the most common process that I've participated in, and that is consistent with how human rights commissions in similarly sized municipalities downstate conduct their business as well. With respect to the subpoenas without an enforcement mechanism, I'm not sure that a subpoena can be issued without a contested case. I think the general rule in the legal universe is that subpoenas have to arise out of an action, and they can't just come out of the clear blue sky without parties being at issue in a contested matter. And
they could have been doing it wrong, but this last city I worked for, they could subpoena people, but they didn't have enforcement, so they couldn't levy fines or anything like that. They would hear cases, try to mediate them, and then refer them to a different agency.
Okay.
Sure.
Yeah, I mean,
Whether it's being done properly or not, I don't know that anyone's ever examined this, so I'm happy to take a look and see. But I tend to agree with Hector as far as having a contested case, as far as issuing the subpoena. With regard to the administrative law judge, we do have situations where we have independent folks, Tom Skorpa and retired Judge Ted Hamer for municipal code enforcement cases, sit in these chairs right here and hear the evidence and make decisions independently, and that certainly can't be done. It's done in other administrative proceedings.
Could you sum up for us what role and how involved you as our city attorneys would be in this process under this new ordinance? Yeah.
The level of involvement would depend on how far.
Could you go to the microphone, please?
Yeah. The level of involvement is going to depend largely on how the participants interact with one another. So in other words, if there is a no probable cause finding, obviously, we don't get involved in that situation. If there's a probable cause finding and the respondent, who's the party being complained about, goes to mediation or some other type of alternative dispute resolution, there would be no involvement from our office unless, I guess, we had to help with the issuance of a subpoena. Where we would become involved, it would be if there is a contested case where the city needed someone to go forward with the burden of proof on a complaint. How many hours that might take, I can't tell you. I really don't know, because this would be a case of first impression. We do similar situations in municipal code enforcement, and those, the hearings, generally speaking, I can't think of many that have taken more than 20 or 30 minutes to present the evidence, but I don't know how hotly contested these issues might be.
If it goes for administrative review, would you be representing to the judge for the administrative review?
If you're talking about a judge over at the courthouse?
Yeah.
Yes, that's correct. According to the city attorney's office, would be representing the same as we do with regard to municipal code enforcement. That's correct.
Are there any judges or attorneys on the commission?
Yeah, Steve Andich is an attorney who sits on. They have a local realtor. There are different groups that there are. We've got a realtor. We've got an attorney. I don't remember all of the designations, but there are different occupations that are specified within the ordinance that are members of the commission. Yes. So, in essence, what we tried to do was do the best we could to give a framework for how this process might work by both reviewing the law and reviewing other local ordinances. We'd be happy to take a look at the city manager's suggestion, looking at a format where there's subpoena, and see if we think that it is viable. And if we do, then I guess we can report that to you, and if we think it's not, we'd report that to you as well.
Vince Thomas. Just historically, several years ago, when I was at Project Now, we had an opportunity, given an opportunity to apply for some grants for creating of the Human Relations, it was called Human Relations Commission at that time. Well, our proposal was turned down because the state said that we were not substantially equivalent to the state's ordinances or laws. And I asked, what did that mean? And it meant that we didn't have subpoena powers. So this goes back almost in 1982. And so we started asking, why can't we get subpoena powers, and which other Illinois cities were substantially equivalent? Well, we got ordinances from Springfield, from Bloomington, Normal. I can't remember all the cities. We got from Dubuque. The mayor of Dubuque came here and even spoke to us, spoke to the city council about how they were using their ordinance. So, given that, I don't know why we don't, and across the river, in Davenport has subpoena powers with their commission. So it isn't something we're asking out of the ordinary. It is something that will enable us to have a better city, and that's what we're trying. Thank you.
Thank you. Okay, any other questions? Council have any questions of anyone? All right. Very good.
I'd just like to thank the council, the mayor, city manager for the opportunity to present this, and also I want to thank the commission members who are here, because obviously we don't know exactly what they know, because they've got the experiences and the history. So thank you very much. I think it was helpful.
Yes. Thank you very much, once again, the commission, everything else for your efforts, and whether it be with this and obviously on the other issues you've had dealt with very diligently, and those, thank you. And then I guess I encourage the council members to get with the city manager and your thoughts and for the future. All right.
Motion to adjourn?
We need a motion.
Motion to adjourn?
Second. Moved in second. Roll call, please.
Alderperson Gilbert?
Aye.
Swanson? Aye. Pulis?
Aye.
Healy?